southbound approaching the CW extension, or are you actually in the Northgate Village Apartments now?
Well, I can tell you it's been a very, very dangerous and extremely fast pursuit. They've been chasing that van right there. Now,
It's exactly what he's doing. Are you Googling the laws right now?
Henderson Police Department's SWAT team responded to the scene and set up a perimeter around the condominium.
I travel in and out of time zone.
And the 3 key rules for a criminal defense lawyer: always on time, impeccably dressed, and occasionally sober.
The yellow sports car up ahead won't stop. Then something happens you might expect in a Spider-Man movie. It wraps around the tire of the fleeing vehicle and stops all forward motion.
Objection, action answered.
I mean, he leaps over the fucking bench.
No, the thing is, that's my property. You have no choice.
Actually, I do, because I found friggin' Xanax bars on your driver's seat. If you want to explain something, explain those.
Cops get very frustrated when you don't answer their questions.
No.
Right, step back forward.
He's gonna go straight. There's a car right here. Got him.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom.
This is fucking hilarious. So he pulls out a joint in court.
Go, 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 go.
Turn on your stomach! Stop fighting us! Stop resisting!
The injury by the police, that may be a separate issue for you to file a civil suit.
Chris, just while he's doing that, talk to me. What were you running for again?
Warrant.
Warrants? A felony warrant, city warrants, what?
Felony warrant on Kansas.
Well, I'm pretty sure they ran you, and you don't have any warrants.
I don't.
No.
No warrants.
No. So all that for nothing, right? No warrants, no nothing.
Yeah.
Police! A little farther, bro. A little more. Okay, go.
Not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
We're there, guys. Got eyes on.
I want to suck it. Yes, I think I would like to suck your dick. I don't think so.
I prefer not to.
I prefer not to, sir. See, that I love that.
So do you wish to say anything?
No, ma'am.
All right, thank you.
Hello, welcome back. Did you miss me? I know you did. I did. I missed you, and you. I missed you all. Welcome back. It's been a while. I've been a little bit poorly, but nevertheless, I will be on the mend, and I just need to suck it up, princess, and get on with it. There's way too many things happening in the true crime world for me to sleep and relax. So today, you remember Ashley Benefield, the Black Swan murder trial that we covered a few weeks ago, and she was found guilty of unaliving her partner Doug with a pew-pew. She was a victim of DV, I believe, and there is a link to a video in the description if you'd like to have a look at that. But basically, we were all shocked when we went through this trial because there was quite a few of our viewers that had been through similar situations, as well as some of us, and we couldn't believe that the jury came back with a guilty verdict, given that to someone who has experienced DV before, some of the signs there were obvious. But nevertheless, good morning, Liz. Hello. Yes, I've pretty much slept for almost a week, unfortunately. Good morning, and welcome. Good to see you all. Yes, I've missed you all. I did jump on quickly last night with AJ on her stream. She was doing the sentencing for some nasty man that unalived his son. I can't remember his name. Anyway, nasty man deserves to be put away. Anyway, Ashley Benefield. So yes, what I've done is I've queued up just the start of the opening arguments just to refresh our memory a little bit, because she has now filed for a motion for a new trial, and I think she might get it. She is, the defence counsel is claiming not only prosecutorial misconduct, but judicial misconduct as well. Oh, 4 puppies. Oh. What kind of dog is it, Elizabeth? I love puppies. Hopefully those 2 are the strong ones and survive and, yeah, rule the roost. But it's still not nice. Yes, so remember, I don't remember, we watched the closing arguments together, and the prosecutors, I felt, were like being extremely harsh and very bullying to Ashley, and I thought that was totally unnecessary, and apparently so does the defense counsel and possibly the Florida federal court. So we'll go through the documents after this. I'll just give us a quick intro on the story. Oh, Shih Chihuahua. And wire-haired terrier mix. Oh, my Lord. So it's a yuppie slipper. Cross between a slipper and a cleaning implement. But I bet you they're cute as. Good morning, Christine. How are you? Oh, dear. Oh, one of each. Pigeon pair. All right. Now, let me... Of course, I've got the wrong screen. It's queued up. Share screen. This one, thank you. All right. Now, let me know if it is loud enough for you. I have it boosted up to 200. Let's go. So, opening statements.
Right on. Opening statements. Let's do it.
With our commentary from prior.
This case is about a woman who very early on.
That's a good question, Adair. That might be one for you, Bri. I know a lot of cases go to a grand jury prior, and I think 99.9% of them.
Who wants to hear that voice?
They were going to continue to live separate and continue to attempt to reconcile, but they were all going to move to Maryland together. Excuse me. At the time that this happened, everybody was in moving mode. There were boxes everywhere, furniture, beds upended. They had a U-Haul that they were using together. They had a pod that was in the defendant's driveway that they were putting all of their things into. And every day around this time, Doug Benefield was going to Ashley's home to assist her in putting these things into the pod, putting these things into the U-Haul, because the plan was that they were all going to pack up in the next few days and move to Maryland. And it continued to try and work on their relationship. The problem was Ashley Benefield knew that this was a ruse. She didn't intend to reconcile. She didn't intend to try to make this work. And the problem was there was a court hearing on September 30th of 2020. And at that court hearing, all of this was going to come out. It was going to come out that she was acting one way when she was.
So you remember all of this? What happened was they they accused her of pretending to go along with him to move to Maryland, and then like doing one thing and saying another, acting one way, saying one thing to the counsellors, saying another thing to Doug because she was playing the game to protect herself and survive. And the prosecutors are making it out that there was this big psych review report coming out on the 30th, and the only thing left for her to do was going to be detrimental to her, and the only thing left for her to do was to unalive Doug, which is all rubbish. Maybe one day, Christine, after I've got a lot on at the moment, after the next Thai trial, perhaps we'll have a look then. But thank you.
Was by herself, and she was acting another way when she was with Doug Benefield. That she was telling him she wanted to work on things, that she wanted to get this marriage back together. But yet when separate, she was saying she had absolutely no intention of reconciling, did not want him around, and did not want this to work. On the 30th of September, this was going to come out. On the 27th of September, she shoots him and kills him. 3 days before this hearing and 3 days before this information was to become public.
Yeah, now that's a load of rubbish. They were also in the middle of a custody battle for their daughter as well. Thank you, Elizabeth. Thank you very much. Hey, Udahab, how you going? Yes, but if you actually read through and then you go through and match it with the actual testimony, like the closing arguments with what they've said, and there's a few different, I'm not sure which ones you've seen, but there's a couple of different motions that she has filed in the last couple of weeks. But we'll go through it, and yes, I disagree with the verdict as well, but I do think they have a foot to stand on. And I was watching Melanie Little break down this particular motion, and she thinks that the juror misconduct in particular is their strongest argument. And poof, poof, she appears again. Oh, you make me laugh. Yes, so the juror misconduct is their biggest argument. Then the prosecutorial misconduct, and there was something else. Oh, there's yeah, I'll go into it in a sec.
Now, there was at the time of the shooting, it was just Doug and Ashley. While Ashley's mother and child lived there, they had gone to the park. As soon as Doug got to the house, Alicia Byers takes her granddaughter and they go to the park. So the only people at the house are the defendant and the victim. And you're going to hear three very important things about this shooting. Number one, Ashley Benefield was the only person that was armed. It was her gun. She had it from before. It's not like she took it away from Doug. It was her gun. And Doug Benefield was not armed. He had no gun, no knife, no club, no weapon.
Absolutely, you'd have. Absolutely. Yes. Yep. 100%. All right. I'll get into this motion because I didn't realize it, but it's 26 pages long. At this stage. Okay. Yes, I do believe that there is a huge chance that she will be not only granted, but acquitted as well. Now, let me move that into the centre. Why aren't you in the centre there? Come on, get over. Go and get. Try that one. No. Oh, look at that. Oh, look how clever you are. That's better. Can you all read that now? Okay. So this is the motion for new trial, request for interview of trial jurors and incorporated memorandum of law. And it was filed, I believe, on the 8th, I think. Oh, it doesn't matter. Just recently. Ashley C. Benefield, by and through unassigned counsel and pursuant to the 6th Amendment and the Due Process Clause of the 14th Amendment of the US Constitution, blah, 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 hereby moves this court for a new trial. As grounds in support of this instant motion, Miss Benefield alleges the following. All right, now let me just go back 1 second and queue up the previous where they actually state this in the closing arguments, because once you listen to it, when she says it, it's a whole different. Oh, come on, silly thing. Verdict, watch closing arguments. I just realised that was the that particular that particular stream we did had Carmen and Gabby and Grandma and me and Brian and AJ. It was huge. So there's about 5 of us in the background. All right. So prosecutorial misconduct. The prosecutor's improper and inflammatory remarks during closing arguments prejudiced Miss Benefield's substantive rights and warrant a new trial. A, the legal standard. Under Rule 3.6 of the Florida Rules of Criminal Procedure, the court shall grant a new trial if the prosecutor was guilty of misconduct or, for any other cause not due to the defendant's own fault, the defendant did not receive a fair and impartial trial. Rule 3.6 requires the court grant a new trial where the prosecutor is guilty of misconduct that prejudiced the defendant's substantial rights. That's the wording, prejudiced, because their actual arguments at the end were inflammatory, were wrong, basically. They were factually wrong. They were biased. They were bullying. They were just totally improper. Improper prosecutorial comments warrant a new trial where they deprive the defendant of a fair and impartial trial, materially contribute to the conviction, are so harmful or fundamentally tainted as to require a new trial, or are so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise. All right, that's the wording on there. The defendant's substantive rights are prejudiced if there is a reasonable probability that, but for the remarks, the outcome would have been different. False statements about Doug Benefield filing for sole custody. During the closing argument, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated, all right, now let's play this closing argument. Remove that one and share the next one. And
I swear that, and she'll tell me, she's like, I've always taught her.
That's I think is.
I had it queued up and everything.
I think it's just like a period,
What
and
happened
then
there?
a doubtful
Irony punctuation is a.
facts are just facts.
Do you know who Sarah Booney's grandma?
Yeah.
Explain what you do. Oh.
That's for another conversation with Grandma.
To see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary?
Yes.
That self-defense instruction called justifiable use of deadly force is very complicated. But there are 2 words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name calling. Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided in less than a year of marriage, they wanted to have a child. This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it.
Oh, so that makes it okay.
I'm sorry, the text messages between him and Ashley. He says, I'll spend the rest of my life making
That's okay. I'm sorry. Oh, look, I'm so sorry, ma'am. You know,
I'm sorry I just beat the shit out of you.
Never heard that from an abuser before.
I've never heard that before.
I object.
Austin, with all of that, I know what she had to go through to get a restraining order. I know all that stuff because it's the same for me. That I am amazed they only gave her 6.
Yes, I'm streaming our stream
so they can
with
take
our
it out
commentary.
and go to court on your behalf for your without you even that information.
So if they go to a DB,
what happens after that? Does any more abuse happen after that?
Yeah.
Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy.
Love
And
bombing.
then within 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last
Absolutely, Brian.
moment that this defendant
Their
ever
job
lived.
is to present the facts. That's it. Present the facts. And where the evidence leads you is where the evidence goes. This is a barrage of bias and bullying, basically. And it's them expressing their own opinions, not only about domestic violence, but about Ashley as well. And her rights were absolutely jeopardized. Absolutely. So if we go back to, I'm not sure where that actual quote is, I didn't have time to pull it up.
Oh, that's not a magic trick. You wouldn't like to respond.
And everything's
But
glorious.
the rebuttal was even worse.
Now all of a sudden, the defendant wants to go with him. I'll go with you. And now,
Absolutely.
we're in a stage where we're acting like we're going to get back together. Because she
No,
knew
they weren't
playing
gonna
the
get back
game.
together.
system was not
She had to
working.
do what she had to
And
do.
she was afraid that if she
Malcolm
didn't
fed
buddy
up.
up to him, he was going to get this child away from her. So
All right. So let's go back again. Wish I could have 2 tabs that showed I could just swap between. Oh, there's more, Bri. Sorry. Not helping the jury decide the ultimate question. 6, vouching for witnesses. 7, declaring that the burden of proof is the defendant's correct. Asserting facts. No, absolutely. Absolutely. There is so much in there that is rubbish. Absolute rubbish. But it's this juror misconduct that's got me. This part I wasn't surprised by, but the jurors, yes, you wait. So this is one of the false statements. On May the 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody, but she's making all of these grand allegations against him that he knows are not true. In other words, she's trying to get full custody by making up shit. this statement was entirely false and unsupported by any evidence presented at trial. Well, when you are a victim of emotional abuse, you don't often have physical evidence. She had the injunction. What else can she do? In fact, the court docket shows that it was actually Benefield who filed a motion on May 4th, not Douglas Benefield. Exhibit B. Where is Exhibit B? Okay, let's go to Exhibit B. There we go. I don't know if you can read that very well. Domestic Relations Judge Charles Sniffen. May 4th. Can't see anything before the 18th on that one, but they're all the filings anyway. Right, so go back to that. The prosecutor further emphasised this false claim in her PowerPoint presentation, Exhibit C, which she displayed to the jury. Exhibit C. Where's Exhibit C? Come to me. Okay, yes, that was her PowerPoint presentation. I can't turn that, I don't think, can I? Oh, I can. Which we saw up on the closing argument. So on the 9th in 2019, Doug finds out she's dating someone else, files for divorce, series of complaints then apparently start, but there are no charges. That's what they're accusing her of. On the 1st of May, the defendant files for another injunction. The 4th, Doug files for sole custody, which is rubbish. Seeing multiple therapists. Defendant acts differently in front of Doug. Social outings, beach movies, rest, absolutely, because she's got to protect herself. So that's attachment C, or Exhibit C. Oh, they had it up. I should have pre-read this, shouldn't I? The standard for prosecutorial misconduct in a closing argument is pretty high. Otherwise, every defendant would have their case thrown out during closings. Yes, that's right, Peter Hef. Yes, but they are not allowed to inflict their own personal opinions into those closing arguments. They have a limited scope as well, and it was improper, the argument. Not all of it, but there was parts of it that were highly prejudicial and improper in nature. Right. This improper argument implied the state had informed not presented at trial, suggesting that Ms. Benefield was going to lose custody of her child. The final motive put forward by the state. So firstly, they said that there was going to be some allegations coming out on this this psych report that was coming out on the 30th, and then when that fell apart because they impeached the Doug's attorney on the stand, then they came up with this second motive, which was losing custody of the child. Such comments referring to matters outside the record are clearly improper. Apparently, Melanie Little went through every one of these case law stated in this document, and they are extremely helpful. A prosecutor may not refer to facts not in evidence, as it constitutes a form of unsworn testimony not subject to cross-examination. The appellate courts held that it was improper for a prosecutor to refer to testimony or items not in evidence. Given the highly prejudicial nature of this false claim about Miss Benefield seeking sole custody, there is a reasonable probability it affected the outcome of the trial. Moreover, the improper comments deprived Miss Benefield of a fair and impartial trial, materially contributing to the conviction, and were so harmful and fundamentally tainted as to require a new trial. Ms. O'Donnell's statement exceeded all acceptable bounds of advocacy and deprived Miss Benefield of a fair and impartial trial. A new trial is warranted on this ground alone. Improper attacks on and belittling of Miss Benefield's character and identity. The prosecutors repeatedly and improperly attacked Miss Benefield's character, calling her a manipulator at least 14 times during closing arguments, and claimed she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. Such vituperative characterizations. Apparently that means bitter and something else. Characterizations of a defendant are improper and prejudicial. For example, prosecutor Suzanne O'Donnell told the jury, the defendant trying to say he was in a fighting stance, he lunged at me. That is just her once again trying to manipulate the system. She's trying to manipulate you to believe that this was necessary. He was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. During the Strait's rebuttal closing argument, Assistant State Attorney Rebecca Friel told the jury, buying the house, I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that, they were talking if you don't believe that they were talking whilst they had this mutual injunction, they were, I'm sure. So she assumed that and stated that in her closing arguments. She assumed and alleged that they were talking during the mutual injunction. Miss Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent, emphasis added. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that mutual injunction was, I'm sure, Miss Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it, emphasis added. This letter we've heard about that Miss Benefield testified to about all these things, it's another effort of manipulation, emphasis added. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. Now, apparently there was something about this letter that they had a massive argument about, and the state didn't want the defence to bring it in, yet they brought up this letter in closing. But I don't know what the letter is. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation, and the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did right, because what did we hear about Dr. Liu and Dr. Haag? They talked to the defendant and she told him what she says happened, right? Emphasis added. I don't even think she told them the same story she told you based on what they said. I would submit to you that those two experts, Mr. Haag was the one you should be depending on, even though he also spoke to Miss Benefield so clearly, got one side of the story, or a made-up story. As Dr. Broder, I think you should take some of what Dr. Broder said to heart. Her concern was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. Well, that would then make him fly off the handle. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was an abusive, horrible man. Yes, you lie. Until you are safe, you lie and you play that game and you protect your ass. Absolutely. Until she was set up and safe, she had to play the game. They have defamed him up and down. No, she didn't say that. She didn't say I was afraid that Doug would freak out on me. I was afraid he'd do this. So she said I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. It's manipulation, and that's what she does. That's what she's done. The evidence has shown it to you, emphasis added. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser that looks good for me, he's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because I said she tried to manipulate the system in South Carolina, ending up being mutual. She tried to manipulate the system in Florida. She got turned down, and she tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did, and she's trying to manipulate you. These inflammatory attacks on Miss Benefield's character serve no purpose but to inflame the minds of the jurors against her. Such arguments are clearly prohibited. The prosecutors also ridiculed Miss Benefield's testimony with Miss Field stating. Now, let's see if I can find the actual rebuttal, because I watched it again and it was horrible. It's one thing for me to read it, and it's another thing. Stop. Ashley Benefield. Okay. Day 6. I just want the rebuttal. Where is it? I thought Law and Crime actually separated that. All right, let's go back up to nearly there. I'll find it. Don't you worry. I'm determined. Oh, there she is. There she is. Okay. Pause. Share screen. Found it. Dokely dokely. Got it. Let's do it. And play, Jody. Play.
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times.
Yes, at. There's a difference.
Why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Dillon remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make you. That's what she told a law enforcement officer. You think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did. Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did, with 45. And let's talk about what we've heard. And it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory. But I want to set some groundworks. Number one, Ms. O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then more than Ashley Benefield's name during that closing. It's not about Miss O'Donnell. It's not about Miss Friel. It's not about either of us. It's the state of Florida, and we have the burden, and we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield.
See, that's unacceptable.
So she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Miss Murphy and her client to dress a certain way. Ashley Benefield's the one that committed a criminal act on 9/27, 2020, when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding what was going to happen. And keep in mind, this ninja we've heard of, 5'9", 169, adult small t-shirt. Adult small t-shirt, size 30 waist.
So?
We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. Look at the text messages going into that week. That's a way to express your love, but apparently to Doug Benefield and to her, it was. So she's said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse, 3 years, he's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child for him over when he could help her, what they would do. She would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There's no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keep in mind, she saw her the night of. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her, this woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them till the cows come home. You won't see swelling. All those law enforcement officers who are trained to look for that, if it was a slap or a punch, there's a big difference. There's a big difference. And if he punched her in the eye,
domestic violence,
her eye would look way different than it does. There's no swelling on the side from a punch. She'd have a Mr. Sam, that sweet old man, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together, and it was fine. It was fine. So he gets so enraged and pops off and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. The manipulator, she manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are, right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things, he could. There was no basis for that. And keep in mind, through all of that, that she's dictating when Doug can see that baby. We don't know if he knew she knew, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. Benefield, he acted the same way in those text messages as she told you he did for 3 years. I'm asking him simple questions and questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's the victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. Because he doesn't believe anybody can get better. And we gunshot in the ceiling. So she had a baby with him? She testified to you that that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. All the while, she's so traumatized. I would submit to you that is not the case. She wanted a baby, and she got one. But Doug was in the way. And as to that neighbor thing, even if he was. Her houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that mutual injunction was, I'm sure, Ms. Benefield was speaking to him when it was convenient for her. When she could get something out of it. It only goes with the rest of it. This letter we've heard about that Ms. Benefield testified all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Liu when it comes to trajectory.
Yeah, absolutely. You'd have factually wrong in so many places. Now let's go back to I'm getting used to this switching through now. All right. So apparently she continues on. Use your common sense. If you cry and have to take breaks and you're racking then you're going to have a swollen face. You're going to your eyes. You're going to be puffy and you're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense or attorney told her, hey, here's tissues. Anyway, all right. Such vituperative characterizations of a defendant are improper and prejudicial. A prosecutor cannot engage in vituperative or perjurative characterizations of a defendant or needless sarcasm, revealing that the prosecutor has abandoned any semblance of professionalism. In the words of one viewer, these prosecutors sound like a couple of high school bullies. They did, and we said that as we were watching it. Still not enough. The prosecutors went even further and claimed Miss Benefield was lying with no evidentiary support. They said she told defense experts a made-up story, again without any basis in the evidence. Such attacks on the defendant's credibility are improper. And they state a whole heap more case law, improper speculation about out-of-court conversations. Prosecutor freely engaged in improper speculation about conversations between Miss Benefield and Doug Benefield, stating, first of all, he wasn't trying to buy, he was trying to rent, regardless, whatever. False claims about defense expert testimony. The prosecutors made false claims about the testimony of defense expert Dr. Emma Liu. Prosecutor Friel stated that Dr. Liu is a medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why would she do that? She did that because she's getting paid to be here. That's why she's here. That's why she's saying those things, and most of them were probably very accurate. There was no evidence presented that Dr. Liu was being paid to testify or that she testified the way she did because she was paid. Ironically, at the time of her testimony, and as this is being written, Dr. Liu had received no fee whatsoever. The prosecutors never even asked Dr. Liu if she was being paid. The improper argument suggested, without any foundation in the record, that the defence had suborned perjury from their expert witness. Such comments are highly irregular, impermissible, and prejudicial. Moreover, the prosecutors improperly denigrate the defence theory and expert witnesses. A prosecutor may not ridicule a defendant's theory or of defence. All right, next one. Improper appeals to emotion and sympathy. The prosecutors made inflammatory arguments clearly designed to arouse the emotions and prejudices of the jury against Miss Benefield. For instance, Miss O'Donnell emphasised, afterwards, she runs over to the neighbour's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. You know, I had to do it. Somebody just help him. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying, and she goes to the neighbour and not once asks for an ambulance, and he dies either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. How would you know? You weren't there. She had an agenda, and it worked for what she wanted, and she got what she wanted, because after she killed him, what did she get? Sole custody of the child. Such arguments that serve only to inflame the minds of jurors are improper, as held, blah, blah, blah. Must not be used to inflame the minds and passions of the jurors so that their verdict reflects an emotional response to the crime or the defendant rather than the logical analysis of the evidence in light of the applicable law. Improper burden shifting. The prosecutors repeatedly misstated the law of self-defense, telling jurors that they needed to evaluate whether Miss Benefield's use of force was reasonable and necessary. So the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are two words that come up all of the time in the instruction. Self-defense. Justifiable use of deadly force would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words, and like I told you a little bit earlier, that's what you need to think of each time you are trying to evaluate whether she used force appropriately. Now, they were going on to say that she had you know, an evil heart while she was doing it. How? Which one's Uda Hef? The emotional sympathy ones. Yes, they do use it at every trial. Ms. O'Donnell further shifted the burden of proof impermissibly in closing argument when she highlighted and emphasised the incorrect instruction in her PowerPoint presentation. Self-defence, justifiable use of deadly force. Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm or a foreseeable felony. Now, I believe that she did feel that. Absolutely. But that's my opinion. So then they go back on to, the depraved heart. That's right. She was justified in using self-defense. Was it reasonable and necessary based on what happened in that house? She's shooting to kill him on September 27th. And we just heard all of that testimony. This argument improperly shifted the burden to Miss Benefield to prove her actions were justified. The self-defense jury instruction clearly states Ashley Benefield does not have the burden of providing that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. So they switched it around. A defendant has a fundamental right to present a defence and to have a jury properly instructed on any legal defence supported by the evidence. Blah, blah, blah. The error committed by the prosecutor in closing argument therefore deprived Miss Benefield of her fundamental right to a fair trial. False representation of wound path. Oh, yes, they did show that. Remember, they showed the image of the body in which angles the bullets entered, and it was supposed to be from front to back and right to left. So it entered at the right nipple and didn't exit, but lodged in the left shoulder. But the angle was front to back, right to left. And in their depiction, it basically showed straight across from right to left, hitting both arms, and basically stated that he wasn't facing her, regardless. It doesn't matter if he was facing her or not. A fighting stance, you turn sideways anyway because your balance, you've got 1 foot backwards and 1 foot forwards to balance. So I got to tell you, those dang Yankees need to stop moving us here. Florida is amidst of yeah, it's nasty. It's not. Florida is just the state of deceit, I think, at this point in time, isn't it? There's too much going on there. Anyway, so cumulative effect. Whilst no single improper comment may require a new trial on its own, the cumulative effect of the prosecutor's numerous improper and inflammatory remarks deprived Miss Benefield of her fundamental right to a fair trial. Now, let's get on to the juror stuff, because that is more. Where is it? Okay. Identifiable juror misconduct. Oh. Okay. Should have redacted that, sorry. Identifiable juror misconduct. Juror 15, Sarah, failed to disclose on her questionnaire material information and further concealed material information during voir dire that would have resulted at a minimum in a preemptory challenge by the defence. A, legal standard. The Florida Supreme Court has laid out a 3-part test for determining whether a juror's non-disclosure of information during voir dire will warrant a new trial. First, the complaining party must establish that the information is relevant and material to jury service in this case. Second, that the juror concealed the information during questioning. Lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. Another stack of case law. Any juror who conceals a material fact that is relevant to the controversy is guilty of misconduct. And this misconduct is prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. The presumption of prejudice has been said to apply unless the opposing party can demonstrate there is no reasonable possibility that the misconduct affected the verdict. Under the rule, a criminal defendant is entitled to a new trial if a juror's misconduct has prejudiced the defendant's substantial rights. The substantial right implicated in this case is Miss Benefield's right to be tried by 6 impartial jurors. Now, that's another issue I've got right there. 6 jurors now. It's ridiculous. That's in Florida, I think. Unless it's a death penalty case. I think they have the 6 juror rule now. The substantial right implicated in this case is Miss Benefield's right to be tried by 6 impartial jurors and her right to challenge the juror for cause or make a preemptory challenge. Thus, it is the duty of a trial court to see that defendants in criminal cases are tried by a jury such that not even the suspicion of bias or prejudice can attach to any member. If there is a reasonable doubt as to whether a particular juror can render an impartial verdict based solely on the evidence presented and the law announced at trial, that juror should be removed, even if the juror affirmatively states that they can be impartial. While challenges for cause permit rejection of jurors on a narrowly specified, provable and legally recognisable basis of partiality, the preemptory permits rejection for a real or imagined partiality that is less easily designated or demonstrable. Once Miss Benefield had established juror misconduct, she is entitled to a rebuttal presumption of prejudice and thus a new trial. Unless the state can demonstrate that any prejudice was harmless. The harmless error analysis places the burden, Okay. The concealed information was relevant and material. So, the information concealed by Juror 15 is highly relevant and material to this case, as the Florida Supreme Court has noted. Relevance and materiality necessarily turn on the facts and circumstances of each case. The 5th District Court of Appeal has explained that a juror's non-disclosure of information during voir dire is considered material if it is so substantial that, if the facts were known, the defence likely would preemptorily exclude the juror from the jury. Juror 15 failed to disclose and or otherwise concealed the fact that, 1, she was a victim of domestic battery on February 20th, 2016, when her live-in boyfriend, Albert, intentionally slapped her in the face with an open hand 5 times. 2, her son, Hayden, was charged with felony battery against his pregnant girlfriend on August 31st, 2014, and Juror 15 was the bond depositor in this case. And 3, she was the respondent in multiple petitions for injunction for protection against domestic violence filed by her ex-husband, Charles, seeking protection for himself and their minor child on grounds similar to those put forth by Miss Benefield against the deceased, Douglas Benefield. Specifically, 1, Juror 15 was a respondent in a petition for injunction for protection against DV filed on September 2nd, 2003 by her ex-husband, seeking protection for himself and their minor child. Let's Exhibit H. Let's have a look, see what Exhibit H is. D, E, no, that's the body. F. G. Let's switch that around, shall we? Can I twist it? Oop. Oop. There we go. Okay, so this is the son. Okay. That's his bond, and the mother, who was the juror, was the bond provider. There's her name, cash bond and purge information, so that's her information there. Probable cause affidavit. So she was the respondent, not the victim. So she was the opposite. Well, can I repeat what it is about Juror 15 that is the issue? I missed it. She was involved in proceedings with domestic violence. So she was the recipient of where is it? DV filings against her. So her husband filed where is it? Juror 15 failed to disclose and or otherwise concealed the fact that she was a victim of domestic battery in 2016 when her live-in boyfriend, Albert, intentionally slapped her in the face. So that was one example. Her son was charged with felony battery against his pregnant girlfriend, and she posted the bond. And then she was the respondent in multiple petitions for injunctions from her ex-husband, who was seeking protection for himself and their minor child, which is here in the Circuit Court of the 12th Judicial Circuit, Manatee County, Florida. Charles, Sarah, petition for injunction for protection against domestic violence. So she failed to disclose any of that in the voir dire process. So what the defence counsel is saying is that he didn't have a chance to make a preemptive strike against her and take her from the jury, which he would have done had he known or had she disclosed any of this. And apparently this is their strongest argument to put forward. But not only that, there was also leaks. The juror concealed the information during questioning. Yeah, we got that. Failure to disclose was not due to lack of diligence, so they asked all the right questions and she still concealed the information. All right, unidentifiable juror misconduct. Lastly, although not yet traceably to an identifiable juror, upon information and belief, an as yet unknown juror brought a cell phone into the jury room and used it during deliberations, constituting an objective act that compromised the integrity of the fact-finding process and prejudiced Miss Benefield's substantive rights, requiring a new trial. During deliberations, a juror brought a cell phone into the jury room and used it while discussing the case with other jurors. This act was in direct violation of the court's instruction and Florida law prohibiting unauthorized materials in the jury room. During jury deliberations, a YouTuber user, That Hoodie Guy, posted comments on the Law and Crime Network's YouTube live stream of the verdict watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Miss Benefield's right to a fair trial. The comments posted on July 30th, 2024 revealed that at 8:20 p.m, 10 minutes before the parties were notified that a verdict had been reached, That Hoodie Guy posted a comment stating verdict incoming. Exhibit A1. Let's go back up to this. Okay, live chat replay. That Hoodie Guy, verdict incoming. Okay, this is on the Law and Crime Verdict Watch. Okay. 10:25, That Hoodie Guy posted a comment stating, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Now, remember, there was 5 women and only 1 single male on the jury. Where is it? Next one. There you go, That Hoodie Guy, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. At 10:27, That Hoodie Guy posted a comment stating, my sister snuck a flip phone in. Where is it? My sister snuck a flip phone in. Lovely. At 10:28, That Hoodie Guy posted a comment stating, I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty. There you go. I am the brother of one of the jurors. Total disregard. 10:28, that hoodie guy posted a comment saying, my sister snuck a flip phone in. She texted me 521, rah, rah, rah. And lastly, there it is there. At 10:30, a mere 2 minutes after that hoodie guy posted that the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that that hoodie guy's information originated from within the jury room during active deliberations. Accordingly, Miss Benefield has formally requested that court interview the jurors in the presence of the parties. All right, see, this is why I'm not always for live streaming trials, because oftentimes it's a, yeah, absolutely, absolutely. And it's wrong. You know, they should both be punished for interfering in the process. And he should know better. You know, if he's a true crimer and he's just posting for clicks, yeah, well, you're right to be skeptical, Udahef, that's fine. But exactly, you wouldn't want them to, if it was you that was on trial right now and someone had posted all this stuff, would you not at least want to question them? Because I know I would. And that's the one thing that they're asking, that they question the jurors now. But this seems to be happening more and more, you know, all this misconduct, not just jury, but law enforcement and all the stuff that's come out with Karen Reid and, you know, Ty Tucker, and just, I just don't understand. This seems every trial has all of these deep-seated issues. And, you know, they've got the evidence to prove the time and everything from this guy. I mistyped. I would want them to, yes. Well, they have applied for that, yes. They've applied for the judge to be dismissed, and they've applied for the jury to be questioned as well. So I don't know how else the information could have got out there. So cell phone during deliberations constitutes juror misconduct. I don't know how, the only way that I can see that that got out there was from someone passing that information in there. And if he's stupid enough to put it up on Law and Crime's website, then yes, I think it's probably going too far, but then I don't know the law and I don't know the impact and the implications of retrying with the same judge. Given that they've heard that information, that's probably where they're going. I think that's me just dotting the I's and crossing the T's, thinking that, all right, would you want to be, I suppose it's not really in the judge's hands, is it? It's in the jury's. But I don't know, Udahef. I don't know enough about the law over there to understand why they would request that. Maybe it's all part and parcel to do with applying for a new trial. I don't know. But yes, I thought that was probably going a bit far myself. So, yes, that the burden then shifts to the opposing party to demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. In this case, the presence and use of a cell phone during deliberations creates a probability that the jury's decision-making process was influenced by unauthorised information. Remember, they went right through till late. I think it was like 11:30 that night. The jury stayed back to deliberate. So that was that one. Now, what else? So the disqualification of the judge. Let's have a look at what that says, shall we? Let's find an answer. I haven't read them. I just downloaded them. Okay. So this is motion to disqualify the Honourable Stephen White. So there's one affidavit from her and there is one from the defence counsel as well. The court's conduct in open court immediately prior to commencement of trial on July 22nd and July 30th verdict improperly prejudiced the defendant. Specifically, the court's declination to voluntarily step aside, as well as the court's arbitrary and capricious refusal to so much as even acknowledge Miss Benefield's request for post-trial bail, created such apprehension for Miss Benefield that she reasonably fears she will not receive a fair hearing and or sentencing because of the court's personal bias and prejudice against her. No previous disqualification motion has been filed in this case, and a transcript of the post-verdict bond request is attached. The actions taken by the court, i.e. its complete refusal to even acknowledge the defendant's motion, yet alone entertain, evaluate, and rule on it, plainly appeared to the defendant that the court never intended to consider it, and remand was the only option. Okay, so they're saying that she shouldn't have been taken into custody straight after the verdict. Very interested in this one. I thought the judge, yeah. Although I was surprised that they wanted to take her into custody, given that she was on pre-trial release. And as Melanie Little was saying, if they do agree to give her another trial, then apparently there is also another good chance that she'll be released on bond pre-trial as well, because she is not a flight risk, and her prior trial, she was on pre-trial release as well. So there's a possibility that she could get out on bond if she granted a retrial. This trial really got to me, I think. I agree that she may have a leg to stand on with the jury. Yes, I don't think there was prosecutorial misconduct. I think there was maybe a degree of prosecutorial misconduct. Depends. I mean, everyone has their own views on it. And as I said, I don't know the laws. I can only go by what I'm reading in the arguments that they're making in this motion, but and from personal experience of DV. So it's extremely common to be taken into custody after you've been convicted of a homicide. Yeah, no, I agree. I was just surprised. That's all. And there was no discussion whatsoever of the possibility of bond or anything like that, or I don't think that it was prejudice against her, though. What else did she file? Let's have a look. She filed a motion to interview jurors. Probably want to see that too, won't you? Share screen. There we go. All right. Let's make that bigger so we can all see it. Miss Benefield submits as follows. The 30th of July, the jury rendered its verdict. Evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. This alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial. During jury deliberations, YouTuber, that hoodie guy, posted comments, rah, rah, rah. So it's pretty much exactly the same as what we just read. A juror, alleged misconduct raises serious concerns about the integrity of the jury deliberations, specifically a juror smuggling an electronic device into deliberations which is not permitted, real-time communications of confidential jury deliberations with non-jury members, influences external to the evidence presented during the trial, access to unauthorized materials. Pretty much. Juror 15 completed a jury questionnaire under the penalties of perjury, which asked, have you or a member of your immediate family been victim of a crime? Juror 15 responded untruthfully to the question by admitting that she, one, had been a victim of a crime when her boyfriend Albert intentionally slapped her in the face with an open hand 5 times, that her son Hayden had been charged in felony battery against his pregnant girlfriend, and for which she was the bond depositor. And she had a petition for injunction for protection against domestic violence against Mr. Ballinger in the 12th Judicial Circuit Court. Juror 15 was a respondent in a petition for injunction for, we've heard all that. Juror 15, a copy of Mr. Walcott's petition is attached here too and provides in part that Juror 15 being threatening and violent, including cussing, slamming doors, threatening and throwing his things at him, requested that his son come and stay with him until Juror 15 can get some help. Juror 15 attempted suicide and was hospitalised on or about July the 18th. She called and told Mr. Walcott that she was going to unalive herself. Constant harassment and threats to his wife and himself, fear that Juror 15 might try to take his son's life along with hers the next time she tries to unalive herself. Wow, okay. So it wasn't just your average DV, this is nasty. Specifically, he requested supervised visitation until Juror 15 showed that she was stable mentally and financially. So, absolutely, I would have been, no, get off this jury. Get off this jury. One thing is the defense is going to argue anything and everything. Absolutely. I agree. I absolutely agree. Yes, it is a mixed bag of a few different things, isn't it? So there you go, people. We have updates. Who else has been watching true crime lately? In my slumber of my week off, I have been following this Sean Finnegan. Need I say any more? Has anyone else seen that trial? Because if ever there were 2 people that were destined or made, how do I say it? This Sean Finnegan and Taylor Shabusiness would be a perfect match in the deranged world, basically. It is nasty. It is a nasty, nasty trial. Revolting, disgusting, confronting. It's pretty much Taylor Shabusiness all over again, minus the bucket. So I was actually thinking of doing a synopsis of the trial, like a quick overview with the main witness, which was his girlfriend. So basically this Sean Finnegan and his girlfriend, Rebecca, I can't think of her last name, they lived together in a house with his mother, who was elderly and into a bit of kinky stuff. And it wasn't uncommon for them to bring home escorts, so to speak, to share the bedroom with for the night. And one day, Sean brought home an escort, Jennifer Paxton, and apparently proceeded to allegedly chain her to the bed and commit all sorts of acts, sexual acts, and allegedly made Rebecca part of that scenario as well, and then eventually unalived her. and put her in a freezer. Had a freezer delivered to the house in the lounge room, put her in the freezer, and then they had the freezer moved up to the bedroom cupboard where she remained. And yeah, that apparently happened. So his trial is just finished. He's just had his verdict read, and they are going through onto the next stage. So I might cover that over the next couple of days, and I will also be doing another update on Mr. Tyrone Tucker and continue on with his trial, as it's creeping up way too fast. Way too fast. I don't like it. The 9th of September is the day. So we've done first 3.5 days. So we shall continue on. I'm determined to do it. Come rain, hail, or shine. So yes, we shall have updates on that one. And if you want me to cover the Sean Finnegan trial, this is where is it? Here's the picture. He's a scary looking man. Scary. Where is he? And it's almost like he stares into the camera and doesn't blink at all. But the reason I was watching this child trial, what interested me was here we go. I'll share this, share screen. Okay, that's the defendant. And that's a good picture of him. It's really, yeah. So, nasty. That's, anyway. So, yes, I might do a coverage of that. And some more on Tyrone, Mr. Tucker. There's no new documents, but I have got the court minutes based on his motions that he put forward in July, which I've got the basic outline of the courts, how the courts dealt with those motions. So we can go through that paperwork, and I shall be in touch with Stephen from Justice is a Process, because he can provide an excellent insight into the legalities of this case, as well as many others. But we are all doing a combined stream together for that trial, which will be fantastic. So stay tuned. Have your notification bells marked on, because there'll be some impromptu lives as well, no doubt, leading up. And what else? What else have we got? Yeah, so there'll be a panel of 4 of us that are covering that trial together, which will be awesome, and it'll be in real time. In the meantime, it's lovely to. Oh yes. Oh, have you watched it, Uda Hef? Did you watch the trial? Because yeah. And Bri, that's yeah. Everyone's following the investigative journalist, but this one, yeah. What did you think? As they're doing the second phase now. Yeah. I think I caught a glimpse earlier. I think they were suggesting that he's got nothing to lose by actually getting up and taking the stand during this phase, and throwing the mud at her, because he's got nothing to lose. And this is a death penalty case, so yes, I found it very interesting. That's what I was going to say. The defense counsel, I mean, the way this all played out for me, I was pretty much 100% convinced that he was to blame, that he was completely responsible. But in the defense counsel's closing arguments, I had doubt created. I actually had doubt created, and I think watching the defense counsel's closings would be something that would be really, really helpful for Ty. Just the way this defense counsel was able, I mean, to basically twist a hopeless case, in my opinion, of guilt and give me doubt. Not a lot, but a little bit. Yes, yes, I'm against it as well, but that's out of my hands, unfortunately, and thank goodness for that. Not something I'd like to make a decision on. All right, well, I might get skedaddling and try and find some coverage on that and some more, and I shall be back tomorrow, same time, same place, same bat channel. Thanks again for watching. If you could just jump on that like and subscribe for me on your way out, that'd be amazing. It really, really helps. I'm getting closer and closer every day to monetization. It's free. It doesn't cost you anything. It just puts you into the algorithm, which then YouTube sends you out to more people who then, thanks, Idhef, you too, darling, who then recommend, people that like watching true crime, they recommend you more. That's all it does, which then gives you more view time, which then gives you more subscribers. That's all. There's nothing. Thanks, Bri. You have yourself an awesome, awesome day, week, night, evening. And I shall keep plodding along, because there's a few little things going on in this little noggin. Thank you for being here. Thank you for sharing again. All your comments. Thank you for the chat replay crew and everyone else. Okay, you have yourself a great day. Bye-bye.
Covering true crime and police arrest, where the judges move